People in occupied territories, under international law, have the right to seek independence, including the right to carry out armed resistance. Thousands of Palestinians were evicted from their lands when Israel was formed. Hence, this video will explain the issue from the perspective of international law. Let us watching the Palestinian stories.
Welcome back to Hardball. We're back with the 39th President of the United States, Jimmy Carter. His new book is called Palestine, Peace, Not Apartheid. And President Carter, why did you use the word apartheid in the book's title?
Well, let's look at the entire title, if you don't mind. The first word is Palestine, which involves the land that belongs to the Palestinians, not the Israelis. I didn't refer to Israel because there's no semblance of anything relating to apartheid within the nation of Israel. And I also emphasized the word not, that is peace and not apartheid. That's what I hope to accomplish with this book, is some move toward that goal. But there's no doubt that within the occupied territories, Palestinian land, that there is a horrendous example of apartheid. The occupation of Palestinian land, the confiscation of that land that doesn't belong to Israel, the building of settlements on it, the colonization of that land, and then the connection of those isolated but multiple settlements, more than 200 of them, with each other by highways on which Palestinians can't travel, and quite often where Palestinians cannot even cross. So the persecution of the Palestinians now under the occupied territories is under the occupation forces is one of the worst examples of human rights deprivation that I know. And I think
even worse though than a place like Rwanda?
Yes, I think, yes. You mean now?
Yes.
I
think the impression now of the Israelis, of the Palestinians by the Israelis, is worse than a situation in Africa like the oppression of Rwandans and the Civil War.
I'm not going back into ancient history about Rwanda, but right now, the persecution of the Palestinians is one of the worst examples of human rights abuse I know, because the Palestinians...
You're talking about right now. You're not talking about, say,
I'm not talking about ancient history.
Ago.
No.
Well, Rwanda wasn't ancient history. It was just a few years ago.
You could talk about Rwanda if you want to. I want to talk about Palestine. What is being done to the Palestinians now is horrendous in their own territory by the occupying powers, which is Israel. They've taken away all the basic human rights of the Palestinians, as was done in South Africa against the blacks. And I make it very plain in this book that the apartheid is not based on racism, as it was in South Africa, but it's based on the desire of a minority of Israelis to acquire land that belongs to the Palestinians and to retain that land, and then to exclude the Palestinians from their own property and subjugate them so that they can't arouse and demonstrate their disapproval of being robbed of their own property. That's what's happening in the West Bank. And the people in this country, in America, never know about this. They never discuss this. There's no debate about it. There's no criticism of Israel in this country. And in Israel, there is an intense debate about the issues in this book. In this country, no.
I agree. I mean, I wish we had that sort of debate that they're having in Israel. I wish we had that in the United States. But give us a sort of sense, how much of the responsibility for the conflict, the Israeli-Palestinian conflict, do you think belongs to the Israelis for their tactics like seizing land and occupying territory that didn't belong to them? How much of it is the responsibility of the Palestinians for their suicide terror attacks and their bombings within Israel proper?
Well, as a matter of fact, the basic cause of the conflict is a sustained occupation of other people's land by the Israelis. And this is a direct violation of United Nations resolutions. It's a direct violation of the International Quartet's roadmap. It's a direct violation of the commitments that leaders of Israel have made in the past at Camp David when I was president and in Oslo, promising that Israel would withdraw from occupied territories. They have failed to do so. In response to that, and I'm not excusing them, there have been acts of violence. As a matter of fact, though, Hamas, the #1 accused persons of violence, have not committed an act of suicide bombing that caused an Israeli life now since August of 2004. And I hope that they won't do that anymore. Other participants of the Palestinian society, smaller ones, have committed some atrocities. But the loss of life in the entire occupied territories has been horrendous.
You are going to entertain the people who shot the feet of Palestinian footballers. Yeah, there's two kids, 18-year-olds, they'd been to the local football stadium pitch to train, dreamed of playing at some point for Palestine, and some IDF soldiers decided to shoot. They shot one kid 7 times in one foot and 4 times in the other. So obviously they'll never play soccer, but they'll never walk again. Oh, you know, I'm a musician, I just want to play my music. I don't want Roger Waters bullying me. What? They're shooting the fucking feet of 18-year-olds who want to play soccer. Don't talk to me about your freedom of speech. Pay attention.
Zionism has never been a movement for self-determination. It never claimed to be. This is a new claim. We began to hear of something called Israeli self-determination in the 1960s and 70s, and only in the last 10 years did the Israeli government begin to put forth something called Jewish self-determination. The term would be used sometimes in Zionist circles in the 1940s during the terrorist war that Zionist gangs had launched against the British colonial forces in Palestine in the 1940s. Now, Zionism, of course, is first and foremost a settler colonial movement. This is not a national movement, for example, we're trying to liberate its country from colonial forces. This is a movement by European settler colonials who wanted to take over someone else's country and create a settler colony. Father of Zionism, Theodor Herzl, spoke about this openly in his writings. The Zionist organization that was built by Theodor Herzl, it named itself, it used the word colonial for most of its agencies to explain that what it was doing was actually a colonial project. By the 1940s, they realized that using the word colonial and colonizing in their own literature is becoming offensive because colonialism was no longer fashionable at that time in the age of anti-colonialism. So they immediately called a strategy of purging these words from their programs and from the names of their agencies. Israel and Zionism speak of a kind of a Jewish colonial settler project that they now define as some kind of a national liberation group. This is what they used to say, actually, in the 70s and 60s and 70s, that we are a national liberation group, and this was as a result of the rise of national liberation groups around the world that they wanted to capitalize on. I think the split increasingly is becoming between perhaps anti-Zionists and Zionists, including by Jewish anti-Zionists. So liberal Zionists, of course, realized that the image of Israel, which they had propagandized over many years as democratic, was no longer defensible. So, for example, you have a new group in the US, a new lobby called J Street, which again supports racism inside Israel, but is interested in supporting the end of the occupation and some variation therein of the end of the occupation. So they are at odds with the more conservative pro-Israel lobby represented by AIPAC and the other mainstream pro-Israel Jewish American organizations. But really, J Street has not been able to galvanize a lot of people. Increasingly, for example, Jewish Voice for Peace, which is much more critical of Israel, much more critical of Israeli racism inside Israel, and is not Zionist, is the force within the new and young generation of Jews that is challenging these kinds of two options, the kind of a hypocritical liberal defense of Israel or the more honest conservative defense of Israel.
Do you think that it is now the time where Western nations need to deal with Hamas?
Well, I think it's about time for the Western nations to stop the unconditional support, both moral and financial, and in fact political, to Israel. The issue, once again, it's not about Hamas. This reductionist approach of reducing the struggle of the Palestinian people since 1948 to only Hamas is very problematic. Hamas was only founded in 1984. There were decades of suffering before Hamas ever existed.
calls from all over the world for an investigation into war crimes on both sides. The United States says any war crimes investigation will imperil the ceasefire. What do you think?
I don't think this is accurate, Samantha. What the Human Rights Commissioner said was that the aggression from the side of Israel could amount to war crimes. She didn't say the same about the attacks from the side of Gaza, basically. So once again, we're not talking about two sides. We're talking about a nuclear state with one of the strongest armies globally and stateless people who have been suffering for decades. Samantha, those kids were killed, basically, from the side of the Palestinians. Those are not Hamas, and not only, by the way, the Palestinians. Do you remember Rachel Corrie, the American activist, who was killed by the Israelis in 2003? They are killing journalists, they are killing activists, not to say the truth. So once again, it's not a two-side aggression, it's basically an occupation, and Israel is the last colonial power that we know of in our time and age.
What legal regime applies to a situation of occupation? As emphasized by Professor Both, three main principles govern the law of occupation. Firstly, occupation, which must remain temporary, does not entail transferal of sovereignty to the occupying power. Secondly, the occupying power has a duty of good governance for the duration of the occupation. Thirdly, the occupying power may take measures that are necessary to ensure the protection of its own interest and security. Let's briefly examine these three principles. It flows from the first rule on continuity of sovereignty, which can be found in Article 43 of the Hague Regulations, that the occupying power must leave unchanged pre-existing laws and institutions of the occupied territory, except where the occupying power is absolutely prevented from doing so. Indeed, the occupying power is considered to be a transitional authority, which does not assume sovereign power. This principle can also be deduced from Article 64.1 of Geneva Convention 4, which states that the penal law of the occupied territory shall remain in force. However, Paragraph 2 of these provisions contains three broad exceptions to the principle of continuity, allowing the occupying power to subject the population to provisions which are essential to enable this power. Firstly, to fulfill the obligation under Geneva Convention 4, secondly, to maintain the orderly government of the occupied territory, or thirdly, to ensure security of the occupying power. We will briefly get back to these caveats in a minute. It should also be underlined that Article 47 of Geneva Convention 4 reinforces the principle of continuity by depriving any measures that would result in a change of status of the occupied territory from having legal effect. An example of such a measure would be an attempt to annex the territory. Article 54.1 of Geneva Convention 4 guarantees the principle of continuity at both administrative and judicial levels by prohibiting altering the status of public officials or judges, applying sanctions or taking coercive or discriminatory measures against them. Regarding the duty of good governance imposed upon the occupier, it is important to recall that, according to Article 43 of the Hague Regulations, the occupying power has the duty to restore and ensure public order and safety. This duty is further specified by concrete obligations contained in both the Hague Regulations and in Geneva Convention 4, aiming at ensuring the well-being of the population. It implies, among other things, that the occupying power must respect the fundamental rights of the population under occupation, provide the population with adequate living conditions, including food, health care, education, medical supplies and clothing, guarantee the maintenance and, if necessary, the development of an adequate legal order and administrative apparatus, respect private property, protect family rights, and provide a functioning court system which does not violate the rule of law. The respect of these obligations will be particularly important for long-term occupation, which will often require adapting existing norms or institutions to the changing needs of the local population. For instance, in order to ensure the effective administration of justice, the occupying power may engage structural reforms and, for instance, re-establish the judiciary when the judicial system has been broken down during hostilities. It is important to know that fundamental rights, which must be respected by the occupying power, are contained not only in the Hague Regulations and in Geneva Convention 4, in particular in Article 27 of this convention, but also in human rights instruments, including instruments of both a general and a specific nature. The third rule allows the occupying power to take law enforcement measures that are necessary to ensure the protection of its security and interest, including interning members of the civilian population under certain strict conditions, unless there is a situation of armed conflict which may require the use of force. In order to ensure the sustenance of the occupying army, two measures can be taken. Requisition in kind or services as a matter of principle against compensation, as envisaged in Article 52 of the Hague Regulations, and, under certain conditions, money contributions as envisaged in Article 49 of the Hague Regulations.